Good evening, and my name is Amaka Vanni from the University of Leeds, and I'm part of the TWAILR editorial collective. This particular session is on economic injustice, and I will start by introducing my panelists. They'll make, I think, 20 minutes presentation, and then we'll go to Q&A. Before we start, I would like to briefly introduce the audience to international investment law, which is an instrument of public international law. It governs foreign direct investment and the resolution of disputes between foreign investors and sovereign states. International law of foreign investment is a field of public international law that primarily addresses the treatment of investment by states and settlement of disputes between investors and the states. Within this sector or area of international law, the decisions of the courts, the claims commissions, and arbitration tribunals have played key roles in articulating international standards of treatment applicable to foreign investors. My hope is that by the end of this panel, we leave with a thorough TWAILian understanding of the substantive and procedural principles of international investment law. I would like to introduce my panelists. We have on my right hand, Professor Nicolas Perrone. I've known you since Warwick days. Yes. And Nicolas works mostly in the area of international economic law, international investment law, and it's really good to have you here. Thank you so much for agreeing to be part of this panel. And here I have James, and we all know who James is. There is no need to introduce him. Usually, because in Nigeria, I'm from the Igbo tribe, and we tend to revere our ancestors. I'm not saying James is an ancestor. But normally, in this regard, what we usually do is we get like a hot drink, like scotch or rum, and then pour some on the ground to just, thank him and just for everything he's done and leading the way. So just James, thank you. So Nicolas, over to you.
Thank you, Amaka. And it's going to be tough to do anything now better. Yeah, wow. Well, thanks first thanks for the invitation all the TWAILR Law Review team, to Amaka, but also thanks for bringing us here together. I think that's, so this morning Suji was talking about all the difficulties you had to go to make it happen. And I think that's great that we are here, thanks for that. And I was asked to talk about perspectives on trade and investment law from Latin America. I was thinking exactly what's the best thing to do with my 20 minutes. And you know that the EU and the CELAC are meeting today and tomorrow. And Ursula von der Leyen stated a couple of days ago before the meeting, Europe is back in Latin America, as we have good news now. And Latin America responded, we are very happy that the old world is interested, but it's not only about critical raw materials, it's also about big issues like poverty and inequality. But still, Lula is trying to get the EU-Mercosur agreement, a typical free trade agreement, So I think there is a bit of a tragedy at the moment in Latin America when it comes to international economic law. And the tragedy is not only about the lack of ideas, like genuine ideas from Latin America for Latin America, but also I think there is a case of there's no cooperation in the region to try to create the conditions for those ideas to fly, even if we got those ideas. So Latin America is not answering to the European Union with a real counter proposal. It's just asking to the EU to do the free trade agreements that the EU used to do a couple of years ago, just the same agreements, So it's not very original for the region. So I think it's a tragedy because I've been looking at the history of international economic law in Latin America, and my sense is that it used to be different. And I want to tell you what, in which way I think it used to be different, in a way in which ideas were not just about like, having how we can play with the language of a treaty, add investor obligations, or create a multilateral, a permanent investment court, but rather a sort of different vocabulary. We're just putting on the table a different vocabulary, of engagement. And often that was done, with certain conditions that were there, which I think is interesting. So I'm going to go very quickly historically, because you can say how the North reacted to that. And sometimes the North had to kind of adapt its strategy to what Latin America was putting on the table. So it's not that always we were just going to, a meeting like today and saying, we want to sign the same free trade agreement you were signing 5 years ago. There was like putting something on the table that was more genuine like that. So first, I want to start with an investment law example, and then I'm going to use some trade examples too. We all know about Carlos Calvo, probably, so there's no need to introduce that. But something that is interesting is that Calvo was not talking in the vacuum. So discussions and talking about non-intervention in the late 19th century in Latin America were pretty much dominant. And we know about Arnulf, because of Arnulf Becker Lorca's work, that actually was one of the most important contributions of Latin American international lawyers. So Calvo was speaking the language of non-intervention, national treatment, but that's it. You're not going to intervene in my country. That means I'm going to, resolve questions with foreign investors through my courts and through my law. Now, something that is interesting here, if you look at the work of Elihu Root, is that he engaged with Calvo in Calvo's own terms. So in the early 20th century, what Root was saying is pretty much the same, with the exception of denial of justice, with the exception there is a minimum standard of treatment, which, by the way, Calvo to some extent agreed to. So it was quite interesting to me that the meeting was not a meeting of you asking the other for their own models, I'm just taking your rules, but there was rather a dialogue with ideas that were created in Latin America, and there were conditions for non-intervention. I mean, I don't have time now to elaborate, but that was not just an idea, it was certain conditions happening in the continent. Later on, again, investment law, we know Mexico, the Mexican Revolution, not just a revolution in terms of the law, but also just to reform the economy, property rights were reconsidered. And there were like two important events then. When Mexico nationalized, Eduardo Hay wrote to the US government saying, we are not going to pay full compensation, because if we pay full compensation, basically we cannot do any revolution. That's not in any investment law textbook. What you find in investment law textbook is the answer. Carter Hall saying you need to pay prompt, adequate, and effective compensation. But we don't know that the way that Hall did not come from nowhere. It was an answer to Hay. So it's not that the US was just, it was that kind of this back and forth that was creating the law. Not just we go into a meeting saying we want the same treaty you were offering a couple of years ago, rather a sort of a dialogue. And the same happened with the Claims Commission that was created during the first years of the 20th century between Mexico and the US. So the commission was, a reaction of Mexico using its sovereignty to implement certain measures, but the US used those commissions to create the minimum standard. The near case is a case which US used. Now we all talk about the minimum standard. That's sort of the antecedent. But it was in a dialogue again. Now we move to trade. The International Trade Organization, the post-war, the US and the UK, they had their model, but it was pretty much 18 Latin American countries and India that got independent a couple of years before that said, okay, we're gonna get that kind of trade that you want, but we want to tie trade to development. So there was a lot of changes in the model that the US and the UK took to the negotiations, eventually to Havana. The famous Article 12, it's just the invention of Mexico. Mexico got there and said, we want investor obligations and we want to tie investment to development. And we want to say explicitly that investors had to behave in a way that complies with the plans, the host development plan. And that, of course, the US Senate rejected it, among others, because its national Chamber of Commerce told the US, business interests in the US, we don't want this anymore. They told the US to include investment in the ITO Charter, and then later said, we don't like the outcome, so just get rid of the ITO Charter. But what's interesting here, the US put something on the table, and then Latin American countries and India went there and said, actually, you know what, we're going to repurpose this. We're going to add a different vocabulary here. We're going to talk about different things, not just trade the way you want to talk about trade. The fourth moment I want to talk about is the resolution on the permanent sovereignty of natural resources. You know, that was a proposal of many countries during the decolonization. It was Uruguay and Bolivia first who asked for the UN to consider this question. And this is interesting because it was the third war now. Many countries from Latin America, India, countries that were like getting independent in Africa and in Asia. And it was again the US. Now, it was again this time the US that intervened with the content of the resolution in a way that's interesting. We normally, I mean, 12 people normally think that this was a great step for the law. But Novoa Monreal in 1970 thought it was a failure. And Steven Schwebel also wrote an article just after he was working for the State Department, saying that was a victory for the US in an article published in the American Bar, in a review of the American Bar Association. But again, it's interesting is that the two are actually having a dialogue. You know what I mean? It's not just somebody's putting on the table and you just buy it. I think that's, to me, it's very powerful. Although I think I'm with Novoa here, and I can explain you why. I don't think that this resolution is such an important milestone for the global South, and actually could even be described as the opposite. And Schwebel may actually got it his way. The fifth moment I want to talk about is CEPAL and the relationship between CEPAL or ECLAC, you know, the Economic Commission for Latin America and the Caribbean, and the GATT and later UNCTAD, because, you know, the International Trade Organization did not work out. So when CEPAL was created in 1949 and afterward, it was a question not only of, you know, we want to change this provision or that provision, but actually of a different language. And just the language that CEPAL was talking about was about cooperation. And this relates also with the work with Jorge Castañeda, which is a very important, famous Mexican international lawyer. I think we need to rediscover if you want to. So when Castañeda was saying, and this was kind of echoing CEPAL, non-intervention was fine when we just wanted to be good neighbors, but we want to work together, to get together, to understand each other, and to, you know, engage with the North in equal terms. We need cooperation. And that is not just, you know, being good neighbors. We need to be really like partners. So he was in Mexico and the international order, he was pushing for a reconsideration of the way Latin America was looking at international law. So non-intervention is not enough now. We need more. We need cooperation. We need solidarity. And something else so that CEPAL and international lawyers like Castañeda and Grospiel were talking about is that they were attacking MFN. The idea that all countries were treated equally and that they should, you know, give you the most favored nation treatment was not appropriate when some countries were rich and other countries were not rich. They're saying you cannot treat different countries in the same way because we know how it's going to end. So it was a clear attack to the idea of, you know, a liberal international law. And they also were very critical of the idea of reciprocity. I don't know, but you probably, if you are in, have any notion of trade law is about reciprocity. I give you a concession, you give me something in exchange. So if you are very rich and I'm very poor, I got very little to give and you have a lot, you know, to ask for. So they were saying it doesn't work with reciprocity, you know. So we need special and differential treatment, or we need something else like that. So all this language eventually made it into the GATT with the enabling clause, with the general system of preferences, but not exactly the way that people like Breivik, for instance, had imagined, because they wanted a general system of preferences, not just you saying, oh, I give one to Africa, I give one to India, but it's not exactly the same, and I'm going to put you to fight with each other, and on top it's not permanent. So if you don't follow certain conditions, I can withdraw it. So again, what is interesting to me is that even if we, you know, the South did not get exactly what it wanted, that was, you know, a very interesting dialogue here. And CEPAL, I think, was very crucial. And then eventually, Breivik went to UNCTAD, and there is a history here. Probably, if later, if you want to, we can elaborate on that. But yeah, I think it's very interesting how this idea and this dialogue occur. So the way the law was made, you know, I mean, there were certain conditions happening. There were certain exchange of ideas. that I think it was very important. And then there is a moment for Latin America that I think is very significant, which is the Charter of Economic Rights and Duties of States. You have investment and you have trade there. And so the story of CERS is very interesting. CEPAL always wanted, what CEPAL originally envisaged was a very close collaboration with the United States. When that did not work, they were in the 50s, the industrialization, like substituting imports, but eventually then you have the Alliance for Progress in the 1960s, that failed. Prebisch moves to UNCTAD, and Latin America gets very disappointed about it, and they try to take the agenda and, you know, get together with the Third World. And that is the negotiations when the new international economic order by the end of the 60s gets stronger. And Echeverría in 1972 in the UNCTAD meeting in Santiago proposes the idea of CERS. And Jorge Castañeda, there is a very short article by Grospiel, which is an Uruguayan national lawyer. Echeverría suggested the idea, people supported it, and then all the Latin American group with Castañeda and Grospiel went to another door, wrote a draft, and then Echeverría submitted that to the United Nations. That's why if you look it into Spanish, it's not CERS, it's the Carta Echeverría. So there are many interesting ideas about against reciprocity there, against MFN. Foreign investors had to comply with domestic law, and there would be trial by domestic tribunals. That's European Union probably. So Robert Meagher says actually that CERS it was a culmination of the CEPAL project when it got when it got like you know, materialized in legal terms. So this is in a way is the high point. You know, we get to put all the ideas together. We get it to through the United Nations. It's different from the permanent sovereignty of natural resources here. It's very clear, both the trade side and the investment side. The idea was to create regional system, the Third World system, there was one in Latin America. The idea was creating similar ones in Africa and Asia. But what happened later on for Latin America, I want to argue and say it's a tragedy. The tragedy is basically all these genuine ideas, but also the conditions for creating those ideas were lost. We forgot about them, and we are living in a sort of tragedy ever since. So Lula is telling you, give me the free trade agreement that you were giving countries 4 years ago, because we don't know what to ask you out of. And what this means? So after CERS in Latin America, there's been a vacuum. We forgot about Jorge Castañeda. Many of the people who worked with Castañeda then ended up doing other kind of stuff more closer to neoliberal work. So in a way, there is first a distortion after CERS. So we know that Prebisch was advocating for not only import substitution, but also export development models already in 1960. But if you read, I don't know, Vanni Roderick, he says, no, they never did that. So actually, they were much more sophisticated, and governments did not listen to them. But that's a different point. They didn't lose on a level of ideas. They were lost for other reasons that we can discuss. So in a way, it was distorted. It doesn't work economically speaking, but actually what happened is slightly different. Then there were coups. No, of course, 1973. Thank you. In Santiago, that's, you know, everything like intellectual life was over. Instead of that, we got genocides in Chile, genocides in Brazil, genocides in Uruguay, genocides in Argentina. And for many years after, we've been living in a state of amnesia. We just forgot about this. No, we don't know about it. And there's an issue of language, of course. They wrote in Spanish only or in French when they wrote in a foreign language, and these kind of things did not get, you know, it's not in English, so maybe they didn't get so significant. So today, I guess, yeah, we live in this situation of tragedy. You could say that Mercosur in the 90s was slightly different, but Mercosur was just one event. Actually, it's the automobile agreement. Then it didn't really fly economically speaking. Maybe politically, yes, but not economically speaking. The Andean community is just being, you know, getting less and less relevant. And instead of that, what has happened is that Latin American countries started to sign free trade agreements with the United States and with the European Union, no? And the idea is who signs first. So Chile said, oh, great, because I signed first. And then Colombia signed, and then Ecuador, even with Correa, signed a free trade agreement with the European Union. You know, he was criticized for that because there were no ideas. Of course, you had ALBA, but ALBA was mainly political. And I want to kind of claim similar about UNASUR. It was mainly political coordination, but there hasn't been really economic coordination. So you don't have the conditions of possibility. They don't coordinate economically, and we lost all the ideas. So in a way, I think we are in a situation of tragedy. I just want to finish with a glimpse of hope. There is a small country, one of the tiniest countries in Latin America, that around 2014, 2016, that was governed by Rafael Correa, and that's Ecuador, had the idea of a new financial infrastructure. Or one of its ideas, which is the legally binding instrument on transnational cooperation and human rights, is still being discussed. So how is it that a very small country like Ecuador managed to propose a legally binding instrument, take the question of transfer and technology and climate change to the World Trade Organization in 2014, and have it discussed at the TRIPS committee? How is it that a small country like that could do that, and a country like Brazil cannot do it? Is it, and I think academics in a way, and I want to finish with this, we are a little bit responsible about this too. We are not thinking as originally as they were thinking maybe in the 1950s, in the 1960s. Maybe the conditions of possibility are not there, but we are not really contributed to make them happen. Some of you ask about the praxis, and I think there is a question there. I see sometimes there is an inflation of ideas. We have a lot of great ideas, but it's very difficult to think that any of them can be implemented. And I wonder then if we also need to concentrate on how to make these ideas happen, and try to make this tragedy change into a glimpse of a different future. Thank you.
Thank you, Nicolas. That was really good. So his presentation basically took us across over a century on the ideas, economic law, and the engagement of Latin America with international investment law, international trade agreements. We saw the different phases with the first phase, and we saw, or rather he explained to us the importance of key actors, the kind of brilliant ideas that compared to the 1950s and what we have now. As he mentioned, it's a case of, at the moment, or rather the Latin America is in a state of tragedy and a state of amnesia. And I like the fact that you ended your presentation with, on a positive note, because TWAILians we've been accused of being nihilistic and always criticizing and not offering solution or whatnot. So you ending this presentation with on a hopeful note, especially the influence and the participation of a tiny country like Ecuador. It's good because even though we as TWAIL, we are tiny compared to mainstream European, Eurocentric international law, we're going to do something massive like what Ecuador is doing. So thank you very much.
So thank you so much, Amaka. This is the first time I've been referred to as an ancestor, and libations poured with that reference. But it also confirms the comment earlier this morning about the old people with creaky knees. So Tony actually disbanded TWAIL 2 in Singapore. So I think there's something going on here. As you can all say, I mean, congratulations to the TWAIL Review Collective. This is absolutely amazing. Bringing everybody here together. All the organizers, our hosts, including Liliana, who we were at Harvard together when we were dreaming up TWAIL. I just tell one very quick story about TWAIL. I hope this is not counting against my time. The mission statement almost didn't happen because I was seated like right here when the last panel ended, and my goal was that I was going to rush up and distribute the mission statement to everybody. And this is because, and I tell this story very intentionally, this is because I think people assume that that statement had, unanimous support and it was effortless and it was going to happen. Absolutely not. The statement disappeared. I had to go back to my offices at TWAIL. I always have to have a backup. I had a backup stash of the statement, and I came back and we were able to do what we needed to do. We didn't ask for permission, because if we'd asked for permission, I'm sure it would never have been. Anyway, I digress. So Nico has done a really great job of providing the historical backdrop. And I'm going to bring the discussion to date. I'm going to be discussing about the reform of the attempted reform of the international investment system through the United Nations Commission on International Trade Working Group 3. So Working Group 3 is where a lot of action is right now. So, if you have old creaky knees, you can't think about 100 years. You can just think about the moment, have a good night's sleep, then tomorrow morning you wake up. So these things have been happening for the last couple of years since late 2016. And in my brief intervention, I want to make the claim that the nature of reforms that are happening of the international investment in Working Group 3, UNCITRAL Working Group 3, are essentially of a procedural nature. They fall short of fundamentally reorienting the substantive rules of international investment law. In effect, if you fall asleep, and I don't blame you, we had a great lunch, the reforms that are being proposed in UNCITRAL Working Group 3 are to make the ISDS, the Investor State Dispute Settlement System, more efficient so that the people who make money out of that system can make more money and much faster. That's basically that is what the reform process in UNCITRAL Working Group 3 is all about. So the things that are not in the reform process are the substantive standards that protect investors. For example, the fair and equitable treatment rule, full protection and security, national treatment, the most favored nation treatment, the umbrella clause, the Howe rule of prompt, adequate, and effective compensation as a standard of compensation on expropriation of foreign-owned property. These clauses have been interpreted extremely broadly by arbitrators over the last several decades, as you read in the background reading for this session. In my view, these are some of where the rot in the international investment system lies. And if you don't touch them and only make the system more efficient so that the system can run faster and people can make money faster, then it's basically not even a sideshow. So my claim is simple, that all this talk about reform is re-entrenching and legitimizing the system. I could end here, actually. That's on the action is not where it should be, not just from a third world perspective, but just from a perspective of wanting to actually do the entire international investment system differently. Nothing is going to change. Now, as we know, I mean, this system is dominated by a very small group of people. Has dominated the ISDS system, the Investor State Dispute Settlement. They dominate that system. A small group of white men, my original thought. Some white men have written about it, if you don't trust me. So it's dominated by a couple of white men and a few dominant women. If you read Sergio Puig's very good work. The other types of people who are largely present are academics and intergovernmental organizations, and the ISDS bar, the lawyers, the counsel that appear on behalf of the transnational corporations in these cases. These are all people who are really very friendly to the system. Sorry, it's the thing. So all these people are the people who are controlling not just the reform process, but also the debates within the reform process. So just to emphasize, in case you haven't fallen asleep, I know this is not interesting stuff. The current ISDS-centric reform process reveals the privileging of the most organized interest groups among all those involved in international investment law, especially the lawyers, whether they are counsel or appear as arbitrators. Of course, the academics, like myself, and think tanks and all sorts of other people. It excludes from the purview other constituencies who are directly affected by the investment projects that in the first place lead to these ISDS cases. And you know, these are not neat categories, local communities, indigenous groups, peasants, and so on. These groups are not represented. After all, these processes are taking place in Europe and in North America, in New York, and is it The Hague or somewhere like that? So the issues that are now on the table for the reform process and this is not me, this is directly reading from their documents. So let me tell you what they are talking about. Number one, the consistency, coherence, predictability, and correctness of arbitral decisions. So that's like the top priority. It's all incoherent, so we just want to make it all predictable, blah, 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 blah. Concerns, number two, concerns on arbitrators and decision makers, such as ethics governing their conduct and arbitral diversity. And, you know, so things like codes of conduct for arbitrators, the whole debate about double hatting, you know, arbitrators who are also serving simultaneously as counsel. Number three, concerns about costs. Yes, of course, it's about money, costs and duration of ISDS cases for the cases to go faster, multiple proceedings, shareholder claims, reflective loss claims. There's some talk about investor obligations, although that's not being taken seriously, and counterclaims. Number four, establishment of ISDS-specific permanent institutions like the EU has proposed a standing court, something like an investment appeal court. Number five, in ICSID, the International Center for the Settlement of Investment Disputes, streamlining procedures such as reducing delays and increasing efficiency and transparency. For example, making publication of awards a default rule and disclosure of third-party funding, and making electronic filing the default rule. So this is not James Gathi's claim. This is what they are doing. It's all about the process. It's not about the substance. The substantive issues I mentioned are not getting any attention. So let me outline some things, of course, that are excluded beyond the substantive standards of international investment law. First, how the rights international investment law confers on investors effectively undermine domestic regulatory choices. You know, this has been a central concern, as we just heard from Nico. It was the reason we had the Calvo clause and the other clause that prohibited use of force, the Drago doctrine. These types of issues have always been at the center of international investment law in the context of the North-South relations too. And this is really the central claim. If you have not fallen asleep on this part, how ISDS creates a fundamentally unfair and asymmetrical system of justice. Only investors can sue states. States cannot sue investors. It's a completely lopsided system. It guarantees rights for investors in ways in which states can never, ever enjoy those rights with the kind of automatic recourse that the ISDS process creates. Of course, regulatory chill, we know this, developing countries get awards of sometimes millions, if not billions of currency in their own local currency. Many don't want to regulate, for example, tobacco. I mean, if you don't believe me, there is a great, one of the US comedians, John Oliver did a great show on how big companies, big tobacco companies wrote to African countries, small African countries, telling them, do not dare pass any tobacco regulation. If you do, we're going to bring big cases and you're going to lose big time, citing, by the way, dissenting opinions from the Australian High Court that were on the other side of this issue. Anyway, I digress. Number four, how these reform processes do not address the market failures. These market failures, we are very aware of them. The incentive structures for investors are very simple. You can go and invest, you know, in Colombia, leave all the environmental damage and all sorts of other damages. You externalize those costs, never internalize them. You'll never face any consequences. But still, you can get an award in your favor. So this UNCITRAL Working Group 3 that is widely celebrated in the literature in international investment law, including by many scholars in the third world and many governments in the third world, which, by the way, are not participating very effectively. I see, I'm being told the government of Colombia is one of those. I don't know, I didn't say that. Just demonstrates that we are at a moment, in my view, not of reform, but of retrenchment. But the reform is being paraded very loudly and being paraded around the world as if the kinds of questions that I'm very interested in, sort of what I call the unequal, unfair, and unjust rules that are the status quo are still going to remain in place even after this reform process. So I see Amaka has begun looking at the cards. So what would some radical reformist agenda that would be transformative include? First of all, in my view, it has to include ending the exclusive privileges investors enjoy at the expense of states, such as the non-reciprocal right that investors have to bring ISDS proceedings against states. 2, getting rid of international investment law as we know it. Or at minimum, refocusing the attention of international investment law to more squarely address the priorities, the interests, the needs of stakeholders that are most directly affected by these investment projects, and not just the indigenous people and the local communities, but the general populations in each of these countries that have to have less education, less healthcare, because investors have to be paid out. So I think, in short, my claim is that the current reform efforts are not going to change anything. We are at a moment of retrenchment, but the struggles that we are seeing at the moment is merely but the latest iteration in the continuous struggle to address international laws and fair and equal and unjust rules. In fact, as Nico was telling us, that is why I want to invoke, as I end, Vasuki Nesaya, who urges us to use rebel imagination to identify the plural ways in which international investment law can be reimagined and how we can address and advance those alternative pathways. The ones that are most interesting to me are the ones that are beyond the systems. I have some beyond inside the system. I'll not talk about that. And I've already talked about the ones beyond the system. I think that we have to review the substantive standards of international investment law to make any difference. That's what would be radical reformist reforms with a transformative impact. If we leave those standards in place and merely accelerate the process and make it, have all sorts of tinker at the margins to make it more efficient and run faster, it just means the arbitrators will line up their pockets faster. And by the way, there are many these systems now just not made of just a group of white men. It's a growing group of people, including from the global south, some of whom you may be seeing. So I think that I wanted just to maybe I'll say this in the Q&A session about some of the stuff that I have some beef with some in the literature, but I just end by saying that maybe another way that we might think about how, as TWAILRs, about how we might think about this reform process is borrowing from the very interesting discussion in the abolitionist literature. TWAILRs have to go beyond the given Perrone's, as we had this morning from the keynote. I think that there are ways of having rebel imagination that go beyond the terms of the debate that have been set, for example, in UNCITRAL Working Group 3, and no one else will go there except us. So thank you very much.
Thank you very much, James. That was quite interesting. And again, I'm happy that you ended in a positive note. The key claims James made is that the current reforms we are seeing, it's not really changing anything, but instead it's retrenching and deepening the unfairness and the asymmetric power divisions within the international investments system. James also talked about how the ISDS, the way it's created, the way it's running currently, continues to enforce this unfairness and asymmetric power divisions, and basically how even though there is so-called reform on and changes and discussion going on, what is happening within this space is the privileging of most organized interest groups such as lawyers and academics and think tanks. Meanwhile, people most impacted by the decisions of the tribunals and the arbitrations, the local people, are excluded. Thank you very much for that intervention. Thank you very much, James. That was quite interesting. And again, I'm happy that you ended in a positive note. The key claims James made is that the current reforms we are seeing, it's not really changing anything, but instead is retrenching and deepening the unfairness and the asymmetric power divisions within the international investments system. James also talked about how the ISDS, the way it's created, the way it's running currently, continues to enforce this unfairness and asymmetric power divisions, and basically how, even though there is so-called reform and changes and discussion going on, what is happening within this space is the privileging of most organized interest groups such as lawyers and academics and think tanks. Meanwhile, people most impacted by the decisions of the tribunals and the arbitrations, the local people, are excluded. Thank you very much for that intervention.